Welcome to Medmarc's webinar series. I'm Kate Klaus, staff attorney with Medmarc's Risk Management Department. Thank you for joining us for this installment of Medmarc's webinar series, fittingly titled 2020, a year unlike any other. We have a fantastic panel of speakers for you today to discuss the year in litigation such as it was. And with that, I am pleased to turn things over to Sonia Valdes, Medmarc's Vice President of Claims, to introduce the panelists.
Thank you, Kate. Good afternoon, everyone. Thank you for joining us. This is at least our 10th annual end of the year webinar summarizing or highlighting the development of the life sciences industry. I'd like to introduce my co-presenters. First is David Waxman. He is the partner in the Chicago office of Saul, Ewing, Arnstein, and Lehr, where he serves as co-chair of the products liability practice. David has represented Medmarc in clients nationwide since 2005. David is a graduate of the UPenn Law School. Next is Andy Hall. Andy Hall is a senior claims examiner with Medmarc. Andy is a graduate of Wake Forest University, a Demon Deacon, and the University of Pittsburgh Law School. He's a licensed attorney in Virginia and DC, and had been litigating a number of years with a well-known law firm before coming to Medmarc. Lauren Hulbert has been with Medmarc for 15 years. She's a senior claims examiner at Medmarc. She's been handling large complex litigation for Medmarc for a few years now. Her degree is in math. She has a BS in mathematics with an emphasis on actuarial studies from LSU, a proud tiger. She has earned her CPCU, AIC, and AIN designations. And lastly, and certainly not least, is the newest member of our Medmarc Claims team, Scott Lazaro. He has 17 years of P&C experience. Scott comes to us from a large national personal lines carrier. Next slide. Welcome. You'll find that the agenda is similar to it has been in the past few years. We will go through some of the life sciences litigation, some of the important decisions, verdicts and settlements. We can't ignore the 800-pound gorilla in litigation, which is the opioid litigation. And you'll hear from Andy Hall to discuss some of the defense and coverage issues. And then most of our presentation, frankly, will be devoted to COVID-19 and the PrEP Act. I'll also discuss some of the virtual jury selection and trials, which are a byproduct of the COVID-19 pandemic. And lastly, I will look into my crystal ball and try and give you an idea of President-elect Biden's FDA priorities. Next slide. But first, I want to set the stage and talk about a little bit about product liability cases. For the year 2019, and I should point out there's a 1-year lag in these stats. We're still compiling the 2020 statistics. This is from LexisNexis. There were 5,200 product liability claims filed versus 4,900 in 2018. That's the highest volume since 2010. Most of these cases were medical device and pharma cases. This particular industry had more cases than automotive, airplanes, consumer goods, or any other industries. Where are these cases being filed? The large MDL cases are being filed in Eastern District of Louisiana, notably before Judge Alden Fallon. He has a lot of experience doing these large MDLs. He's presided over the Actos, Risperdal, and is now sitting on the Xarelto litigation. In second place is the District Court of New Jersey, who has their fair share of MDLs. And the new contestant in the MDL sweepstakes is the Northern District of Florida. You'll be hearing more about the Northern District of Florida as they've been assigned the 3M earplug cases. Now, this is a case that I think is the numbers of cases are gonna be so large, they're gonna overwhelm the other two courts. 3M implant cases involve 3M earplug cases involve earplugs sold to the military that didn't work, and our servicemen suffered hearing loss as a result of these defective earplugs. There's quite a few cases that have already been brought. Who is filing these cases? Well, Weitz and Luxembourg had by far the most product liability cases filed. Weitz and Luxembourg is an asbestos firm in New York. They're branching into life sciences. So I think that most of their cases still are asbestos. The Weitz and Luxembourg case was followed by Beasley Allen, an Alabama firm that's involved in a lot of life sciences cases, and we're seeing them in many of our cases. So anyway, I want to set the stage and turn this over to Dave Waxman, who's going to walk us through important decisions of 2020.
Thank you, Sonia, and good afternoon, everyone. Thank you to my Medmarc friends for inviting me to join you today. So if you polled first-year law students on reasons why they dropped out and got their MBA, studying preemption and jurisdiction would be amongst the leading reasons for them to leave law school. I will now be spending a couple of minutes talking to you about preemption and jurisdiction, which happen to be the key topics for most of the procedural legal developments in 2019. With respect to preemption, it deals with a small amount of cases, but it's critically important in the area of brand name medications. And there are certain claims within that realm that are based on failure to warn pursuant to state law. The question in those cases arises whether or not the warning which the plaintiff seeks in accord with state law would not be allowed by the FDA. If the FDA would not grant the warning that the plaintiff seeks, the manufacturer is in an impossible position, and therefore this is called impossibility preemption. Albrecht was a 2019 US Supreme Court case addressing impossibility preemption, and it set the guidance for the lower courts on how preemption should be dealt with, particularly with respect to the impossibility issue. Albrecht says that impossibility has to be addressed by the clear evidence standard. And the clear evidence standard requires two things. It requires that the FDA was fully informed of the warning which the plaintiff says was required by state law, and also that the FDA informed the drug manufacturer that it would not approve the requested change to that label, including the warning. The issue that follows the definition of the standard is who makes the determination of whether or not the clear evidence standard was met. Historically, there was no consistency as to whether the court or juries would make a finding on what the FDA would have done. Albrecht made it clear that the court should be making that decision. And if we go to the next slide, we'll see that as Albrecht has been interpreted in the lower courts in 2020, it has gone essentially as the Supreme Court had dictated. The lower courts have followed their gatekeeping obligation, and juries are now being kept out of the business of ruling on impossibility preemption, which is obviously a positive thing for the industry. As to whether or not preemption is being found, the decisions have gone both ways. And I note a couple of the recent cases from Florida, Georgia, and California. These are all fact-driven decisions on what the FDA would have done in any particular situation. Let's go to the next slide and let's deal with jurisdiction. Unlike preemption, jurisdiction affects everyone. It affects where you are sued, and as we all know, not all venues are created equal. For example, if you have a choice between defending a case in Oklahoma City or in the Court of Common Pleas in downtown Philadelphia, it does make a difference. The key case that we'll work off of here was the Bristol-Myers Squibb case, a US Supreme Court case from 2017. In Bristol-Myers Squibb, it was a Plavix case based in California. And there were a number of California plaintiffs who claimed that they were injured and brought their cases in California courts. A number of plaintiffs from out of state sought to join the California litigation. They had the same claims, they had the same types of injuries, and the California courts had allowed the joinder of the foreign or the out-of-state plaintiffs. The Supreme Court threw out the claims of the out-of-state plaintiffs, saying that they did not have a basis for proceeding in California. In dealing with jurisdiction, there are two types of jurisdiction. There's general jurisdiction, which is basically where a corporation is at home. Corporation's principal place of business and the corporation's place of incorporation. In those venues, a corporation cannot almost without exception, challenge jurisdiction because that is where the corporation is at home. All of the skirmishing on jurisdiction is with the second element of jurisdiction, and that's called specific jurisdiction. And that is where the relationship between the facts leading to the lawsuit and the location where the case was filed is addressed. And specific jurisdiction is what was involved in Bristol-Myers Squibb, and as you'll see, it's been involved in important cases in this year. Specific jurisdiction generally follows state statutes that allow injured plaintiffs to bring actions in their own state. The historic remedy for a defendant when a in-state plaintiff brings an action is that they can remove the case to federal court. So that is the only alternative that a defendant has to avoid being in state court where a plaintiff has been injured. But if we go to the next slide, we'll see that there have been some developments in this area. The most recent substantial case is the RIOS case. RIOS is an Illinois Supreme Court case from 2020 dealing with Essure. And the lower courts had ruled that the Illinois plaintiffs could proceed based on a provision in the state civil code that they had been injured and they can go ahead and file in state court. Similar to Bristol-Myers Squibb, non-resident plaintiffs with identical claims to those raised in Illinois had sought to join this action, and the appellate court in Illinois allowed the non-resident plaintiffs. The non-resident plaintiffs claimed that clinical trials and physician training occurred in Illinois, as well as certain marketing programs, which therefore justified bringing their claims in Illinois. The out-of-state plaintiffs were not injured by any activity that occurred in Illinois, and as a result, the Illinois Supreme Court, following the US Supreme Court in Bristol-Myers Squibb, threw out the claims of the out-of-state plaintiffs, ruling that there were inadequate ties between their claims and the Illinois courts, and as a result, the out-of-state plaintiffs had to file their claims elsewhere. One interesting note, if we go to the next slide, there was a concurring opinion in the RIOS case filed by Justice Kilbride in Illinois, and Kilbride followed the dissenting opinion of Justice Sotomayor in Bristol-Myers Squibb. And Justice Sotomayor and Justice Kilbride took a very broad view of jurisdiction, basically saying that when you put a product in the stream of commerce, wherever it shows up, as long as it's foreseeable that it ends up there, you have to defend the case there. Justice Sotomayor was on the short end of an 8-to-1 decision. Justice Kilbride was on the short end of a 5-to-2 split, filing his concurring opinion. And while Justice Sotomayor has lifetime tenure, Justice Kilbride was just voted out of the Illinois Supreme Court, and he is now former Justice Kilbride. The next slide talks about the future of jurisdictional analysis. And it involves a very important case that has just been argued before the US Supreme Court. We anticipate a ruling probably in the second quarter of 2021, but it involves Ford Motor Company. There were two cases that were consolidated. One was in Minnesota, one was in Montana. In both instances, the car that was affected in the accident was not designed, made, or sold in the jurisdiction where the accident occurred and where the lawsuit was brought. In Minnesota, a Minnesota citizen filed an action in Minnesota State Court. In Montana, a Montana citizen brought an action in Montana State Court. Ford challenged jurisdiction in both instances because it did not conduct any activity in either of those states. It did not design the car in Minnesota or Montana. No cars were made in those states, and the cars that were involved in these accidents were not originally sold in those states. So the question is, will the Supreme Court narrow jurisdiction such that you actually have to have activity relating to the lawsuit in the state that you file? it could be an incredible, significant rewrite of jurisdiction and limit the number of places where defendants can be brought into court. With that, I will hand it back to Sonia.
Thank you, David. So I'm following past presentations. I'm going to talk to you about some notable verdicts. And so the verdict page, unfortunately, is notable by the lack thereof verdicts, because the courthouses effectively closed in March and didn't reopen until September. And along the East Coast, it quickly closed because of spikes in the COVID-19 pandemic. So what we're seeing is I've talked about a couple of pre-pandemic cases, and one is a good one. The shining star was a pelvic mesh case in Florida called Salerno versus Johnson & Johnson. Here, the jury found that the plaintiff hadn't shown that the artisan mesh product was defectively designed. The plaintiff had a ton of medical issues, including severe stage 4 pelvic organ prolapse and surgeries for bowel obstruction. The defendants were able to help the jury reach the conclusion that the mesh was not the cause of the plaintiff's medical problems. In the talc litigation, the big story was J&J's challenge to the mind-boggling verdict of $4.7 billion granted to 22 plaintiffs in Missouri. On appeal to the Missouri Supreme Court, this award shrank to $2.1 billion. However, the Missouri Supreme Court was quite critical of the actions of J&J, calling them outrageous. There are two other large verdicts: the Moore-Cabrera verdict in Florida for $9 million, and another whopper $787 million verdict for 4 plaintiffs in New Jersey, which was later reduced by Judge Viscomi to $186 million. That's significant, the last one, because J&J is New Jersey. It's the largest employer and is almost always identified with the state. So the fact that they were willing to whack J&J doesn't portend very well for J&J in future litigation in New Jersey. More recently, a state court in Illinois, a judge dismissed accusations that Allergan manufactured a defective and dangerous breast implant without giving proper, timely notice and adequate notice about the warnings, adequate warnings. The basis for the dismissal was preemption, as breast implants are a class 3 device requiring a pre-market approval for the FDA for its warnings. So the FDA had looked at its warnings and said they were adequate. So in this case, the class 3 device and preemption law prevailed. In another favorable case, a Georgia federal judge cleared Boehringer Ingelheim's of a wrongful death case, alleging that it failed to warn about the bleeding risk of blood thinner Pradaxa. The judge here also cited preemption as the basis for a decision, concluding the plaintiff had not shown the company had acquired new information which would have required a strengthened warning. It's the old CBE, changes being affected exception to labeling before approval by the FDA. Two other bad decisions in places that are not normally considered bad jurisdictions on the same day involving the same product, and that's Biomet's Magnum's metal-on-metal hips. The plaintiff in both cases alleged that the metal-on-metal hips, that they had shedded the metal residue straight into the bloodstream, causing toxicity in the bloodstream and requiring revision surgery to remove the hip implant. In both cases, there were jury verdicts. In the Nicholson case, which is at Iowa federal court, the jury found $3.5 million. $2.5 million of that was in punitives. And in the same day, the Missouri federal court found in favor of the plaintiff, Mary Baines, and awarded her $21 million. What's notable is we're talking about federal court in the Midwest, where generally these type of verdicts outside the larger verdicts are Missouri state court, not Missouri federal court. A couple of takeaways regarding verdicts this year. I didn't discuss them, but there were a number of cases nationwide that were dismissed by the judge in favor of the defendants due to expert testimony regarding causation. The judge as his role as gatekeeper, was not impressed by the experts put forth by the plaintiff and dismissed the actions. There were a couple of cases, as you've heard, dismissed on preemption grounds. This is not normally the case. Most of the time, we've not seen judges willing to dismiss the case on preemption, at least not in the drug cases, and most medical devices, unless they're class 3 products. Lastly, the trend in 2019, 2020 was a trend towards reduction in verdicts to comply with the ratios of compensatory damages to punitives that the state has already considered to be appropriate. We did see this in a number of the cases that I discussed. Next slide. In terms of settlements of mass torts, last year at this time I was telling you it was a very, very bad year for J&J. Well, it's a very, very bad year for Bayer. Bayer settled 3 large classes of claims in a settlement totaling $11.2 billion. They settled crop damage due to dicambia, another one of its products, environmental contamination caused by leaching of Roundup pest control, and then more significantly, the settlement of non-Hodgkin's lymphoma bodily injury cases linked to Roundup. The bodily injury cases have been very expensive to defend and had resulted in billions of dollars worth of verdicts against Bayer. And they've also gotten a lot of negative press. When you add this $11.2 billion to the next settlement that Bayer reached, it settled 90% of its 39,000 Bayer eSure cases for $1.6 billion. You're talking about a very expensive year for Bayer. Bayer eSure is a class 3 reproductive contraceptive device linked to severe pain and scarring in women and necessitating the removal of the device by multiple explant surgeries in most cases. Also, a large settlement, Boehringer Ingelheim, the manufacturer of Pradaxa, a blood thinner, reached settlement with about 2,900 plaintiffs. The amount of the settlement is unknown. It's confidential. I've looked everywhere to find it, but I can't seem to find it. This is significant. It's the second major settlement for Boehringer Ingelheim for Pradaxa. In 2014, Boehringer singled 4,100 cases for $650 million. So Pradaxa to them, I'm sure they're making billions of dollars on it, is costing them a pretty penny in settlement. Pradaxa, by the way, has been linked to excessive gastrointestinal bleeding. And then lastly, in J&J, despite its reassurances to the contrary, J&J did agree to settle 1,000 talc cases for $100 million. The allegations were that the talc product caused mesothelioma and cancer. The company still faces 20,000 cases. A July Bloomberg article estimated that the resolving the remaining cases would cost J&J over $10 billion. And now I'm going to shift the discussion over to Andy Hall, who's going to talk to you about the 800-pound gorilla in litigation these days, and that's the opioid litigation.
Thanks, Sonia. I'm going to spend the next little bit, like Sonia said, talking to everybody about opioids. So if I can get the next slide, please. This is essentially kind of the agenda, the overview of where we're going to head. And you're going to see a consistent theme here on what I'm talking about, in that trials are delayed, which should be no surprise to anybody given COVID-19. But despite that, there are still lots of things going on, both in the federal court MDL and in some of the state court cases. And then I'm going to end my discussion, or the litigation section of it anyway, talking about some other developments. There were some criminal actions that were noteworthy, and a couple settlements, and a few other things of that nature. Just real briefly, for those who are not quite as conversant on this topic, what we're talking about here when I'm talking about opioid litigation are lawsuits seeking damages arising out of the opioid epidemic. And the damages sought in these lawsuits have been quite broad and can range from increased hospital costs to increased police forces, judicial services, et cetera, et cetera. The lawsuits have been brought by governmental entities, hospitals, third-party payers, Native American tribes. There's been a large number of lawsuits brought on behalf of infants suffering from neonatal abstinence syndrome, so those born addicted to opioids. And there are, as of the last count, I was able to find about 3,000 of these lawsuits across the country, 2,000 of which are in the federal court MDL pending in Cleveland, Ohio. So that's why I'm going to spend a lot of my time talking about that particular MDL. And that's before Judge Bolster, who has been handling this for a number of years now and has not been without controversy, as we'll talk about with some of these decisions. But it's also worth mentioning there are state court cases and MDLs pending in a number of jurisdictions, the most important of which are probably New York, and West Virginia has a large MDL. So there are a couple state court developments I'll touch on as well. So the next slide that we're on already, trial delays. There were essentially a handful of cases that were supposed to go to trial in 2020 or early 2021 related to the federal court MDL that have been delayed. The first is the first pharmacy Bellwether. So you may remember at the end of 2019, there was a trial that was supposed to go forward against manufacturers and distributors brought by Summit in Cuyahoga County, Ohio. Those were settled essentially on the courthouse steps. Before trial, Judge Polster had severed out the pharmacy defendants and was going to have I think he called it Tier 1A trial that was supposed to take place this year. That trial has been indefinitely delayed. Second pharmacy Bellwether, which is set for reasons I'm going to talk to you about more in depth in a couple minutes here, has also in the last couple of weeks been delayed until October 2021. And that is another Ohio-related case brought by Lake and Trumbull counties. And then the West Virginia non-jury Bellwether trial, that is a trial against 3 distributors, was again just in the last couple of weeks continued indefinitely. And the defendant in that case, I'm sorry, the judge in that case is very eager to move forward with that trial and is kind of begrudgingly continuing it due to COVID. Interestingly, and we'll touch on this more later, he's considering having virtual elements to that trial. He has indicated he's not interested in that, including trial testimony, but there may be virtual elements to that trial. So if we can get to the next slide, please. All right, so while Judge Polster and all these Bellwethers have not gone to trial this year, there have been some important rulings. I'm not going to go through these line by line, but know there are always a flurry of motions being decided. I think I see at least every other day when I read on the opioid litigation, there's some motion being decided by Judge Polster. So generally, kind of the Cliff Notes answer to these motions is he is trimming claims from these lawsuits, but he's not dismissing anything in its entirety. So these claims, these claimants, defendants, they test the legal theories here, and some of them may be trimmed, but none of them have really been eliminated as a class of claims or claimants or defendants. The other thing to note is there was a bunch of motions practiced kind of in the middle of this year relating to setting up a $3 billion common benefit fund to compensate the plaintiff's attorneys involved in this MDL for their time. Judge Polster declined to set that $3 billion common benefit fund at this time. That may come in the future, but that may be even farther down the road for another reason I'm going to talk about here in a minute. So if I can get the next slide, please. All right, so there have been a couple important appellate rulings this year. The Sixth Circuit is essentially, that's the appellate court that sits above Judge Polster. So when rulings he's made in this MDL need to be appealed, that's where they've gone, at least so far. There's 2 important rulings to talk about here. By far the most important of these, I think, is the negotiating class being struck down. So in 2019, Judge Polster, who has been very interested in pushing this towards a global settlement since he received the MDL, he set up a negotiating class, which essentially took the federal rule of civil procedure related to class actions and tried to create a mechanism where these plaintiffs' attorneys could reach a global settlement or big settlements of these claims, and then the state and local governments could opt in or opt out of the settlement. It was fairly unique and quickly appealed to the Sixth Circuit, and the Sixth Circuit said, we don't agree that you're able to do this pursuant to the rules. And so they struck down the negotiating class. The plaintiffs' are not happy with this, and they have sought, they call it an en-banc hearing with the Sixth Circuit, which essentially would be all the judges on the circuit court hearing the case, as opposed to the 3-judge panel that heard it in the first instance. The second thing to be aware of is the Sixth Circuit. This relates to that first pharmacy Bellwether we just talked about. They reached a decision that Judge Polster allowed dispensing allegations against these pharmacy companies to be added too late in the litigation process. That left that trial, that pharmacy trial, with only distribution claims. So Judge Polster, once that decision was reached by the Sixth Circuit, essentially unilaterally told everybody they needed to pick a second pharmacy bellwether that included dispensing allegations. So that was done. That's the second bellwether that I talked to you about with Lake and Trumbull counties, Ohio. The defendants were less than pleased with Judge Polster essentially setting the second bellwether so quickly, and they've petitioned the Sixth Circuit to remove him as the trial judge, citing bias. They did this in 2019, and those efforts failed. This current effort seems to still be before the Sixth Circuit with no decision yet. Next slide, please. So in addition to the trials we've talked about and all that, there's a handful of bellwether cases that have been remanded for trial. The first of which is the West Virginia case I've already mentioned, so I won't get into that. The second is City of Chicago. That's a lawsuit targeting manufacturers. San Francisco as a test case for distributors, and then the Cherokee Nation is the first tribal bellwether. As you can see from the slide, none of these has gone to trial. The West Virginia case will probably be the first one, and the other three are essentially in various states of pretrial discovery, pretrial motions, things of that nature. So these other bellwethers are kind of moving along as best they can as well. And I should also note there's indication from Judge Polster that he's going to probably set a couple other bellwethers, remand a couple other bellwethers, including one involving a hospital in the near future, but that hasn't been done yet. Next slide, please. All right, so I mentioned there are a number of states that have their own cases, that have their own MDLs. I'm going to touch on two things here. The first of which is New York State. So the state of New York and 2 Long Island counties were set to begin a jury trial in March. As you all may recall, COVID started in March, so that trial was delayed and rescheduled. At this point, it's been rescheduled for February or March of 2021 with jury selection next month. It's going to be live streamed, which is an interesting decision and a decision that the defendants were against. And it's really going to be one of the first trials to kind of get all these different classes of claims and defendants and everything together into one trial to see what a jury will do with that. The first trial to take place in this opioid litigation period that we're in right now was a case brought by Oklahoma against J&J in 2019 that resulted in a $465 million verdict. That case, not surprisingly, is now on appeal to the Oklahoma Supreme Court, and they're essentially fighting about Oklahoma's public nuisance law, which we don't really need to discuss in this context. Next slide, please. All right. So a couple other things that I found to be interesting. First, there's really one settlement and one proposed settlement that I noted here, one involving Mallinckrodt and the second involving J&J. Particularly interesting to me is Purdue Pharma. This is within the last couple months has reached a deal with the federal government to plead guilty to 3 felonies. They're paying around $8 billion in financial penalties and dissolving the company. Some of the members of the Sackler family are going to pay $225 million in penalties. They're not, Purdue, as you probably know if you've paid attention to the opioid litigation, they were essentially the original target defendant and the entity that these plaintiffs' attorneys are kind of pinpointing as being the start of the epidemic. So that was a big deal. There's been at least one other company, Indivior. They reached a $600 million settlement with the federal government this year. And I read this morning, in fact, that a key DOJ official who's been dealing with kind of the opioid epidemic, he indicated they're going to be looking at enforcement actions against pharmacies in 2021. So we may be seeing some more of these types of deals announced either next year or maybe in 2022. And I had to mention NSYS. NSYS is a smaller, at least compared to Purdue, smaller player in all this, but they received a fair amount of notoriety for their sales and marketing practices. A number of their executives were sentenced to prison time earlier in 2020, including their founder, who was given 5.5 years in jail. All right, next slide, please. So before I end, I needed to cover a few coverage decisions that came out in 2020. And there's 4 cases I'm going to mention. Largely, they flow from the Acuity decision. So I'll start there. The Acuity decision was a declaratory judgment action. So Acuity, the insurer, sued Masters, its insured, to get a ruling on whether there were coverage for opioid lawsuits pending against Masters. In 2019, I believe it was 2019, the trial court said there is no duty to defend, there is no coverage here, because the plaintiffs are seeking economic damages, not bodily injury to specific individuals. In June of this year, the Intermediate Appellate Court in Ohio reversed, said at least some of these damages could be because of bodily injury, so therefore there's a duty to defend. So that's the current state of the case, although the Ohio Supreme Court is considering whether to accept this matter on appeal. Next slide. So the Cincinnati decision is essentially, this is from a trial level court in Ohio. Again, insurer seeking a ruling about whether it owed coverage to its insured for some of these governmental opioid lawsuits. There were a few grounds given by the trial court ruling in favor of the insured and finding there was a duty to defend, but a large part of the decision was relying on this acuity because of bodily injury language. Next slide, please. And again, you'll see in the last 2 cases I cite, one out of Delaware, which interpreted Pennsylvania law, and then a decision out of the federal court in the western part of Pennsylvania, finding coverage, again, relying on this because of bodily injury language. And last thing I'll note is the Rite Aid decision, the one out of Delaware, the petition for appeal is pending with the Delaware Supreme Court. So there may be some further updates next year, depending on whether any of these appellate decisions are rendered. So that's what I wanted to cover on opioids, and I think I'm going to turn it back to Sonia at this point.
Thank you, Andy. So just to highlight Andy's presentation on the coverage, it doesn't seem to be going very well. The last 3 cases have gone against the insurance companies, and what I'm hearing, we're expecting a decision in California and one in West Virginia, who may not also may also go against the carriers. Okay, so moving on to COVID-19 products and 3D printing. Next slide, please. I want to talk to you about the PrEP Act. That's a significant part of what happened in 2020. Many of you have already attended presentations on PrEP Act. I'm going to try and talk about different aspects of it you may not have heard. For example, the PrEP Act itself was not a byproduct of COVID-19. It's been around since 2005. It's been invoked previously for anthrax, Ebola, and smallpox outbreaks. It was declared for COVID-19 on February 4th, 2020. So what does it do? It authorizes the Secretary of Health and Human Services to issue a declaration to provide immunity to certain individuals or entities, covered persons, against claim or loss caused by, arising out of, relating to, or resulting from the manufacture, distribution, administration, or use of certain needed countermeasures, i.e. covered countermeasures, except for claims involving willful misconduct. What are covered persons? Covered persons would be number 1, the United States. Number 2, a manufacturer or distributor of a covered countermeasure and their agents, officials, and employees. Doctors, for example, have been covered under covered person since the beginning of this of the pandemic. Covered countermeasures means a qualified pandemic or epidemic product. It could also be number 2, a security countermeasure. Number 3, a drug, for example, would be remdesivir, which was used very effectively to treat COVID-19 in President Trump. Number 4 would be personal protective equipment, would be a covered countermeasure. Covered countermeasures can be approved by the FDA using the following. Number 1, regular procedures, a 510K or a PMA. Or a covered countermeasure can be an investigational drug exemption application to the FDA, or, which appears to be the way that most of these have been approved in 2020, these products can be approved by an emergency use authorization, EUA, declared by the Secretary of the Department of Health and Human Services. An EUA, an emergency use authorization, can be withdrawn, modified, or limited based on post-market effectiveness and safety considerations. Usually these products are covered under an umbrella emergency use authorization. Now, what about litigation under a PrEP Act? Litigation involving a covered countermeasure requires a showing of willful misconduct by the plaintiff of a covered person or entity by clear and convincing evidence. Sole jurisdiction would be in federal court in DC. The plaintiff can only bring an action for serious injury or death. They require an expert affidavit to move forward. If an action is brought in another jurisdiction, it is subject to a motion to dismiss, and no discovery can take place while there is a motion to dismiss pending. I wanted to talk a little bit about the Defense Production Act because it's often used interchangeably and wrongly with the PrEP Act. The Defense Production Act has been around since 1950. On March 18, 2020, President Trump issued an executive order invoking the DPA, Defense Production Act, to prioritize and allocate emergency responses in response to the COVID pandemic. Basically, the statute allows the president to require companies to offer priority treatment of certain product orders, to allocate certain materials, facilities, and service to further national defense or energy needs. The executive order, President Trump's executive order, declared personal protective equipment and ventilators and other medical resources to be critically material to the national defense so that the president can control the distribution in the marketplace. In other words, what the DPA does is it requires that private companies fill government orders before they fill private commercial orders. There are no decided cases interpreting immunity in the products liability. There are no decided cases interpreting the PrEP Act in the products liability setting. You will hear more about concerns from Andy and David later when they give us their thoughts on the potency of the immunity provided under the PrEP Act. In leaving the slide, I should note that on December 3rd, the Secretary of Health and Human Services greatly expanded PrEP Act liability protections to purely private sector activities related to the administration and in some cases non-administration of COVID-19 countermeasures. Included now by product of this expanded liability are telehealth providers, prioritization decisions, and vaccine administration and distribution activities by private entities. Next slide, please. So I thought one of the things I'd like to look at is, could 3D printing be a godsend during this pandemic? The answer is a maybe. Let's look at what 3D products are. 3D products are a variety of processes in which material is joined under computer control to create a solid object. 3D printing, also known as additive manufacturing, creates 3D objects by depositing materials layer upon layer in accordance with the object's digital model. A key advantage of 3D printing is that they're able to produce complex shape and geometries without the lead time of a mass production cycle. 3D printing is also advantageous because it uses less raw material and may require fewer manufacturing steps. At present, the 3D printing uses mostly plastics and metal powders. Can 3D products, are 3D products covered in the PrEP Act? The answer is yes, they can be covered in the PrEP Act for medical products such as masks, face shields, and ventilators for use during the pandemic. Are they covered under the PrEP Act? They are. If the 3D printed product is a covered countermeasure, then it should be entitled to legal immunities under the PrEP Act. We previously discussed the expanded pathways to the PrEP Act, the EUA, specific approval, or IDE exemption. The FDA issued guidance that face masks do not require a PMA if labeled appropriately under an existing emergency use authorization. Ventilators are also covered under an umbrella EUA. Manufacturers of 3D printed products may submit a request to the FDA in order to have their products added to the umbrella emergency use authorization, thereby bringing them within the PrEP Act. 3D printed products are also covered under the Defense Production Act. The DPA was invoked for masks and ventilators. The FDA has provided specific guidance to address questions regarding 3D printing during the pandemic. But caution here, while allowing the use of 3D printed products, the FDA cautions that 3D personal protective equipment may not provide the same level of effective protection as some other conventionally manufactured types of PPE due to technical challenges and may not meet the testing or production standard as FDA cleared products. Like the Consumer Protection Safety Council, the FDA has expressed concern about hazards such as fire and electrical, chemical hazards such as toxicity, exposure to nanomaterial, and mechanical hazards. They're also concerned about good manufacturing practices on the part of the 3D printed manufacturers. So finally, 3D printed products are subject to the same mandatory voluntary standards and regulatory requirements as other goods. Example would be the FDA or the CPSC. And now I'm going to turn this over to Lauren and Scott for a discussion of COVID-19 effects on the industry and some of the COVID products that we are seeing here at Medmarc.
Thanks, Sonia. So this is just a very quick slide that hopefully shows a lot of good information to everybody, kind of the general impacts of COVID-19 on the industry. And we're going to start out kind of with the Business Insider article that says that, in 2019, the medical device market reached nearly $457 billion. However, in 2020, this is expected to decline to $442 billion. And this is mainly due to lockdowns, both in the US and overseas, which negatively affected supply chains in both device manufacturing and finished goods for sale. These lockdowns also affected the needs for products involved in involuntary procedures. And I think we've seen generally in the news these kinds of trends. And then lastly, as of April 6, 2020, there were more than 2,800 clinical trials and approximately 900,000 patients enrolled at trial sites that were affected by either a partial or total lockdown. And it's estimated that more than 50% of those companies paused recruitment and 75% had stopped activities in total, halting their clinical trials. On the other end, as a result of all of these challenges, the life sciences industry really has stepped up to address some of these issues. 23 companies joined efforts to coordinate with the National Institute of Health, various government regulatory groups, and the Bill and Melinda Gates Foundation to identify and accelerate therapeutics for COVID-19 within a group called the COVID R&D Alliance. Arising out of this alliance is community, and community stands for COVID-19 Multiple Agents and Modulators Unified Industry Members, which is a mouthful. This group it's a global platform for clinical trials, and it's covering currently studying hospital patients with COVID-19. It's focused currently on 3 therapies that are selected based on their potential to suppress or control the immune response resulting in inflammation, which is a symptom of COVID-19. The trial itself is randomized, double-blinded, it's a placebo-controlled trial, and it's going to be onboarded in multiple countries, including the US, Brazil, Mexico, Russia, and others. And so this, depending on how those trials go, this platform is also then expected to be extended to antivirals. So this is a positive movement for the community and for the ability to proceed with clinical trials as a result of the pandemic. Also, as a result of the pandemic, companies have had to have operational adaptations for their life sciences companies. In response to manufacturing and supply chain distributions, life sciences companies have increased their use of digital technologies. And in doing so, these companies have strengthened their relationship with suppliers and created systems and processes to provide visibility so that they can better understand the risks and drive specific actions based on company priorities. They developed ways to quickly reconfigure and maintain supply to their global demand. And they invested in supply chain planning and control tower solutions to better sense and respond and even predict potential supply chain issues. So this is where AI comes into play. As a result of COVID, there have also been an increase of expected production of certain products. Sonia went over, this is PPE, ventilators, respirators, and sanitizing products. But there's also been an increase in lesser publicized products. And so these would include hospital beds and test kits, but they also include the wearable devices. And now I think Scott is going to speak on some of these. Scott?
Thank you, Lauren. Sonia mentioned particularly the 3D printing of medical devices, and the FDA seems a little hesitant to fully endorse the use of 3D printing. As it pertains to PPE, gloves, gowns, face masks, things of that nature, they acknowledge that you can use the technology to print those certain aspects of PPE. However, they feel that they will not offer the same fluid barrier or air filtration protection, such as things that they've already cleared, like N95 respirators. When it comes to manufacturing parts or components of existing medical devices, the FDA's emergency use authorization for ventilators and similar components does acknowledge that 3D components can be made. However, the FDA, again, is still encouraging the use of original parts where available and strongly cautions that you have to check fit and function of any 3D printed parts before you use any such components on an existing ventilator or tubing for a ventilator. When it comes to an entire medical device, well, the FDA really just says, let's talk about it. They don't really have an opinion at this point. And again, they seem rather hesitant to adopt the technology at this point. On my next slide, we're going to talk a little bit about expansion of healthcare access, really to allow healthcare to remain healthcare in facilities, doctors' offices, and hospitals to remain for the more acute cases, for people who need care more readily. At that stage, the industry has responded by providing home use COVID test kits. The FDA has approved a prescription at-home use test kit for COVID-19. It is, again, by prescription only for ages 14 and up. Some of the test kits require you to actually send your sample off to a lab for analysis, thus increasing a delay in the amount of time before you receive your results. Actually, as of yesterday, the FDA approved a home test kit that does not require a prescription. It is an over-the-counter product developed by an Australian firm. It can be used entirely at home. No one is required to go to a doctor for a prescription, and you're not required to send your result off to a lab. You can have results at home within 20 minutes. When it comes to expanding access to medical care, the Department of Health and Human Services is authorizing an increase of usage for non-emergency situations, as the slide suggests, for general wellness visits, medication, non-emergency situations. CMS is also offered an expansion of services to temporarily provide easier access for consumers who are enrolled in Medicare and Medicaid and CHIP programs as well. At this point, I'm going to turn the floor over to Andy and David to discuss more about the future of COVID.
All right, thanks, Scott. So you've heard about all these great products. You've generally heard about the PrEP Act. So Dave and I are here to say, what do we think that means from like a claims perspective? So a couple things that we wanted to touch on here. The first is Sonia's gone through the PrEP Act, but it's important to note the immunity provided by the PrEP Act is a time-limited, at least as of right now, proposition, and the immunity is set to expire October 2024. The way I read the proclamation is that there will be essentially 1 year after that date in 2024 for these countermeasures to be removed from the market, but then the immunity ends. Now, we're talking about a process that's still 4 to 5 years down the road. So there are certainly potential extensions. There's been talk that I've seen of essentially a federal COVID-19 liability immunity provision. That has not passed yet. But in general, there's a question of what happens when the immunity expires. If you're selling a product, I suppose, that's going, or the claim comes up, the lawsuit comes up during this immunity period, everything's great. But there are questions to be discussed about what happens when this immunity expires. I know, Dave, you wanted to address, there are some state immunity provisions that can be in play here as well.
And Andy, just to riff off what you were saying regarding the extension of the PrEP Act, there's an interesting interplay between when the PrEP Act will expire and state statutes of limitation. Obviously, that's something that will play out over time, but that's an issue to keep an eye on. There's a patchwork of state immunity provisions. There's no consistency regarding who's covered. For example, most states have statutes and or executive orders protecting care providers during the pandemic. And at least 12 states have enacted legislation related to COVID liability in general. Now, unlike the PrEP Act, these state provisions essentially do not eliminate litigation. They simply raise the bar for the plaintiff. You need to prove gross negligence or a reckless disregard, but the state provisions do not keep you out of court. And I would suggest that to call them immunity provisions is sort of a misnomer. The one thing I would add before yielding the microphone at this point is the one thing that manufacturers can do to protect themselves, in addition to availing themselves to whatever statutes are there, are update your warnings and your disclaimers. It's really important that you have proper warnings and disclaimers, because that will be some of your best arguments if and when you're brought into court to defend your product. With that, I'll yield back.
All right, just real quickly here. Sorry, go ahead, Sonia.
Go ahead, Andy. No, go ahead, Andy.
I was just going to mention the last 2 points here. I think what we're going to see in terms of how this all plays out is we need to look at the gray market product claims that may exist, the product that's not removed, this countermeasure that's not removed from the market, where something happens to it, 10, 15 years down the road. And then we're going to have to see how the courts actually apply these liability immunity provisions, because as we know with preemption and other things, courts are often hesitant to apply these types of protections any farther than they absolutely have to by law. So with that, let me turn it back to you, Sonia.
Thank you, Andy and David. Next slide, please. So one of the things that is very much a byproduct of the 2020 pandemic is virtual jury selection and virtual trials. We've seen the utilization of this feature by different courts. As I mentioned previously, the courts were closed from March and through September, and they just recently started opening up, and only many of them have closed down again and really aren't setting cases for in-person trial until late 2021. So what is it about? What about jury trials? What's the story with them? Well, the biggest problem right now is that nobody wants to serve on a jury. Consider the example set forth by San Diego and Hartford. They mailed out thousands of jury questionnaires or jury invitation cards and only received 25% of them back. When they were selected, only about 10% of the potential jurors showed up. It was not enough to seat a jury. Should we lower the standard for a minimum jury count in this time of the pandemic? Frankly, that brings its own challenges, and there are constitutional challenges on the state side if we did something like that. Some states are considering enforcement of jury attendance, although that may seem heavy-handed right now, especially when we're reaching the spike that we've reached on COVID cases. Facilities is another factor in why we can't do in-person trials. Most courthouses do not have the ability to physically distance jurors from each other for multiple trials. Also, many courthouses are antiquated. They're old, and they have heating and air conditioning systems are as equally as old. You're lucky you can conduct you're lucky to conduct one trial in some of these courthouses. Lastly, there have been cases where a jury is seated and then dismissed either immediately or during the pendency of the trial due to a COVID-19 issue with a judge, lawyer, or other juror. So what about a fully virtual jury trial, jury selection and jury trials? Well, they may help a little bit on the civil side, but there's some issues here as well. Even before the jury trial begins, there are issues revolving over which jurors should be considered in the pool for a case. That's a big issue in New Jersey. Who whittles down the list of jurors for a particular case? Who conducts voir dire in these extraordinary times? Usually it's the lawyers, but in certain states it's the judges. Here, it's considered almost all the time to be the judge. And then they may be lengthy as well. Consider a recent trial in Florida, the first fully virtual trial where jury selection took 2 days and the trial itself took 1 day. So it's still a lengthy undertaking. Here's a really interesting one. Not all potential jurors have computers or internet access, or they have some computer equipment and some limited internet access. You may be eliminating the participation of segment of the population, i.e. a jury of your peers who cannot afford expensive equipment to participate as jurors. Technical issues cannot be overlooked, even though we've gotten a lot better with Zoom and some of the other technology out there. The issues remain involving demonstrative evidence in the trial, and so technical issues continue to be a concern during fully virtual trials. Lastly, and this was an interesting one, juror inattention. Reports from some of the fully virtual trials have said that juror inattention is a real issue. Some of the jurors have been caught doing other things on their computer. Some were asleep and some are attending to children. So they're not giving 100% of the attention they would normally give as an in-person trial. Well, what about virtual jury selection in trials for criminal cases? Will that take place? Well, not likely due to constitutional issues. The right to a fair and impartial jury, the right to confront and cross-examine witnesses are built into the constitutional protections given a criminal defendant. There are some notable exceptions, though, I should point it out. Texas and Florida are conducting criminal trials in a fully remote settings, although they are doing it for lesser offenses. They're not doing it for any kind of murder or any kind of serious felony. The first fully remote civil trial was held in Florida in Duval County. It was a personal injury case involving a worker at a strip club who was injured while being removed from the premises. It resulted in a verdict of $354,000. There were some challenges required to make it effective. There were prepared questions for voir dire by the judge. The use of the chat function was the way that jurors were able to communicate. Some of the demonstrative evidence did not go in very well, but it wasn't a bad case as the first case because the case was only on damages as the defendant was in default and didn't make an appearance. Will this option survive the pandemic? I'll just mention that federal court in Washington State, which covers the city of Seattle, fully virtual trials are the norm. This is the first court in the country to embrace virtual trials. Judge Marcia Peckman, who is one of the federal court judges in this circuit, has been conducting criminal trials since the pandemic. She's actually presided over four virtual trials. She wrote a book and has been lecturing extensively around the country on this option. She sees this option surviving past the pandemic. She believes this option should be considered when there are multiple witnesses out of the state or country and the case is particularly expert intensive. David, what do you think?
Sonia, I don't look forward to how the courts are going to be digging out. I practice primarily, but not exclusively in Chicago, a jurisdiction that's still dependent on Crayolas and carbon paper. And we are going to have an immense backlog here. I think that court systems that have better financing and better technology may dig out a bit through higher tech trials, but my personal feeling is that lawyers are cheated, and in some way their clients are cheated if you don't have the opportunity to try a case in person. The sterility and the distance of virtual trials, I think, are very disturbing, and I think in some ways they impede the lawyers from doing what they need to do.
I couldn't agree with you more. I really couldn't. I don't even want to do virtual mediations. I can't help it. That's the only game in town. But I'm not thrilled with virtual trials either. Okay, so moving on to the last topic, next slide, please, next slide, the priorities for President-elect Biden's FDA. As long as we have the COVID-19, that will be a priority, dealing with medical countermeasures for COVID-19, and it will remain until everyone is inoculated and the pandemic is behind us. And even then, frankly, I think some time ought to be devoted to a national stockpile of medical countermeasures and having practices and procedures in place for the next pandemic. We've learned a lot of valuable lessons from this one. Let's make sure we have better planning the next time we're caught in this situation. President-elect Biden has indicated that he's going to rely on heavily scientific types and career scientists to head the FDA and the Health and Human Services Department. We can expect him to start naming them sometime in January. The medical product user fee negotiations will come to an end pretty quickly, and they'll involve steep increases for the industry. They're just needed to increase the inspections and enforcement activities of these medical products. I will say that you can expect increased inspections because some of the issues that we're seeing around counterfeit products and contaminated supply chain products from overseas. So we're going to see an increase in these inspections and enforcement activities. Then the last two things we're going to see, which made me kind of laugh, are not laugh, but I mean, it's kind of interesting in that President Trump and President-elect Biden couldn't agree on the color of the sky in the morning, but they do agree that there's a need for a broader availability of generics and biosimilar competition. We need to make these generics more readily available and cheaper for the population. We have to encourage competition. The other thing is in increased supply chain issues, looking at them, have we done everything to protect the public from international supplies? Can we bring manufacturing of these critically needed products back to the United States? So I think those are the kind of things that President-elect Biden and the FDA will be focusing on in the short-term future. That is all that I had. I thank you for your patience, and I'm happy to field any questions that you might have on this presentation.
Thank you so much, everyone. This is a really excellent presentation with a lot of great information. And I think we are running a little bit over on time, but there was one really great question that came in that I would like to put to you. So that is, what do you expect to come across your desk in 2021?
I'll start off, and I'm hoping others in the panel will join me. I think we're going to see counterfeit products, unfit products, claiming PrEP Act immunity. We're going to be besieged by those type of products. In fact, some companies have come to us with these type of products that are questionable. So we're going to see whether or not they truly are covered under the PrEP Act. So I think we're going to see a lot of challenges to the PrEP Act for these type of products. David?
Sonia, I agree. I think the scope of the PrEP Act, and I think that PPE manufacturers will be under siege as we begin to dig out of COVID and dig into litigation. The only other items that I would anticipate, number one, would be all the work that did not get done in 2020. I think there will be a pretty significant move to push things forward. And the other thing, going back to where we started, is the law of jurisdiction may be rewritten, and how that will impact cases across the country remains to be seen.
Very good points. Andy, you have any thoughts?
Yeah, Dave sort of stole a little bit of my thunder there, but I'll bring it from a claims perspective. As we've talked about a bunch here, things have slowed down both in litigation and on the claim side, and that train's got to start moving again. And I think that's going to happen in 2021 and probably for a year or two afterwards to kind of get everybody caught up. So that's both in terms of trials and settlements and mediations and everything else that we do. So that's what I expect to happen next year.
I agree. We're going to be very, very busy in 2021. Anybody else have any thoughts? Okay. Well, thank you very much for allowing us to present. I really enjoyed it. I hope you got something out of it.
Thank you so much, everyone. I know the presentation will be valuable to our audience. Sonia, Dave, Andy, Laura, and Scott, thank you. Thank you for joining us. This concludes today's webinar.